Hello and welcome to Sky's Mental Capacity Act webinar. My name is Hugh Constant, a Practice Development Manager here at Sky, and I'm going to spend the next hour talking through the key points really of the MCA, of the Mental Capacity Act. The MCA, I think, and I hope you agree, is a really exciting and vital piece of legislation. If we implement the MCA properly, then I think we go an awful long way to providing people with the care and support that they have a right to expect. The MCA, as well as being such an exciting law, is also one with a vast scope, it's fair to say. And today we are just going to be looking at the key elements to it. And one part of it we're not going to be looking at, just to let you know, are the deprivation of liberty safeguards, or DOLS, which a topic which merits at least an hour of its own. So I'm sorry if you were hoping for that. At the end of the session, I will be pointing you to some other training and other resources we have that do cover DOLS. But yes, as I say, today is just going to be an overview of the other parts of the Mental Capacity Act. Okay. Hopefully I'm going to bring up some slides on the screen now, and we will go through the Mental Capacity Act in all its glory. Okay. The point of the Mental Capacity Act is this really, to remind us that people have the right to live as they choose. And just as you and I would expect to be able to do what we want, providing it didn't harm others, people with care and support needs, be they in care homes, supported living settings, their own home, have exactly the same right to take risks, to be a bit silly, to live the life that they want. Okay, and that is the right that the Mental Capacity Act gives to people, the right to live life as they choose and to make decisions for themselves wherever they're able to do so. Okay. So this is what we're going to look at over the next hour. The importance of the Mental Capacity Act and its origins in human rights legislation. Then we're going to look at the 5 key principles of the Mental Capacity Act. We'll look at assessing capacity, whose responsibility is and how to do it best, how to make best interest decisions, the protections for you as professional workers under Section 5 of the Mental Capacity Act, when using restraint is allowed, and then some specific elements of the Act, such as independent mental capacity advocates, what the Act says about planning ahead to make decisions for the future, and the role of the Court of Protection. Okay, I hope that sounds okay. Human rights were needed. Well, human rights legislation arose very much out of the horrors of the Second World War and a sense that those horrors must never be allowed to happen again. So it's no coincidence that the big declarations of human rights, the Universal one in 1948 and the European one in 1950, came very swiftly after the end of the Second World War. And it is those human rights that the Mental Capacity Act is there to protect for people with care and support needs. Okay. This is a quote I love about human rights. It comes from Eleanor Roosevelt, wife of former American President Franklin Roosevelt. And she asked, where, after all, do human rights begin? In small places, close to home, so close and so small that they cannot be seen on any map of the world, yet they are the world of the individual person. And I think that's really important to hang on to, because it might not feel that when you're supporting someone with dementia in their room in their care home, or you're taking a guy with learning disabilities out to the pub of an evening or whatever, that you are dealing with human rights. But I would suggest that you are, and the Mental Capacity Act is about protecting people's human rights, as I say. And these might not be grand gestures that you're making, but if you get it right and if you protect people's human rights on your day-to-day work in people's rooms, as I say, you might not be famed for changing the world, but you are changing the world for that person and protecting their dignity and their rights and so on. Okay. So where does the MCA apply? and who does it apply to? It applies from everyone from 16 and above, and it's worth remembering that it is from 16, not 18, that you are presumed to have capacity to make your own decisions, okay? But the MCA is relevant wherever there is an impairment or disturbance of mind or brain, and you can see some of the things that apply in that category, many of which are long-term conditions like dementia, learning disability. Some fluctuate, some like substance misuse, so drunkenness or concussion or whatever, can be quite short-lived. But if someone is in that state, then and there is a reason, therefore, to doubt their capacity, then to make a decision, then the Mental Capacity Act applies. It applies across England and Wales wherever health or social care is delivered in all those various settings. It also, it's worth saying, applies where in banking transactions, housing transactions, and so on. And any decision is covered, from minor ones like what to wear, what to eat, to much more significant ones like where to live, what medical treatment to have, and so on. Okay. And the MCA is important because, as we've said, it is about protecting people's rights. It is about protecting people's rights to make their own decisions while they're able. And if you need to remember why that's so important, I think you only need to pause for a second and think how you would feel were your right to make your own decisions about your own life were suddenly taken away from you by anyone, by staff members, by anyone representing the state. It doesn't take much to realise how vital it is that we respect people's right to make their own decisions. Some people, though, can't, and what the Mental Capacity Act does is provide a framework that where, because of an impairment of mind or brain, someone genuinely cannot make their own decision, that everyone supporting them and working with them has a duty to act in their best interests. And the Mental Capacity Act comes in wherever consent is required. So, as we've seen, whether it's consent over, having breakfast, consent over going out for the day, consent over a major medical procedure, consent over where to live, wherever consent is required, then the Mental Capacity Act is relevant. And you need to make a decision whether someone is capacitated to give their consent to consent to that decision, or if they're not, then you have the duty to act in their best interests. All of this is set out in very useful and concrete detail in the Code of Practice, and anyone that works with people that lack mental capacity has to follow the law and the Code of Practice. And you might not have your own copy, but wherever you work, you need to make sure that there is access to the Code of Practice so you can refer to it when you need. There are, as many of you will know, 5 statutory principles, the 5 key principles that underpin the MCA, and we're going to go through those one at a time now, okay? The first one is that a person must be assumed to have capacity unless it is established that they lack capacity. The person has to prove nothing. They have capacity until you have demonstrated that they lack it, okay? So you cannot walk into a situation and just because someone has dementia or has a learning disability, that alone is not grounds for you assuming that they lack capacity. You have to assume capacity until it's proven otherwise. Okay? And the second point is that you can't say that you've demonstrated that someone lacks capacity until you have taken all practical steps to help that person make that decision, to help that person have the capacity to make the decision. Okay? And we'll have a look later at what some of those practical steps might be. The third one, very popular with a lot of people, is, but not always observed, I think it's probably fair to say, is this notion that just because someone makes an unwise decision, that does not prove a lack of capacity. That we need to allow people to make unwise decisions without taking that to be a demonstration of the fact that they are not able to make their own decisions. And again, we'll look at all of these in a little more detail as we go through. The first 3 are all around the notion that people should have capacity that people have the right to make any decision that they're capacitated to make. The fourth and fifth statutory principles are about what we should do when we have established that someone lacks capacity. Okay, so principle number 4 is that any act that we do for someone who lacks capacity must be in their best interests. Not your best interests, not the organisation's best interests, not their family's best interests, but in the person's best interests. And in addition to that, we need to make sure that any decision is less restrictive, is the least restrictive of the person's rights and freedom of action. Okay, so if someone's best interest can be met without giving them medication, then that is less restrictive than meeting their best interests by giving them medication, for example. Okay, and I think many people, most people working in health and social care can list these 5 principles, and all of us, I think, do our best to adhere to them and to put them into practice in our day-to-day work. But very often, actually, I think sometimes for structural reasons and for sort of systemic reasons, we don't always observe these. And I think, you know, any care home that has visiting hours might be, it could be argued, has, you know, more restrictions in place than are strictly necessary. Or if a place has keypads to make sure that people don't wander out the building, rather than staffing ratios to make sure that there's always someone there to keep an eye on someone. I mean, that is a more restrictive way of meeting people's care needs than it might be. But of course, you know, doing it any other way would have huge financial implications. I guess all I'm saying is that we know these principles and we try to stick to them, but you know, we are sometimes working in environments that make adhering to these principles sometimes very difficult, if not, sometimes very difficult. So I think maybe it's worth you, as I talk, thinking about a time when you have applied any one of these principles effectively, but also a time when you've not applied one properly, or you've misapplied one. I know I've done it many times. I've worked in social work teams for many years, and I have been conscious that there are times when I haven't applied all the principles in exactly the way I should. But take time to think, well, when you did it well, what helped? What factors contributed to it going well? But also when it didn't work so well, what factors contributed to that? Because I think if we start to identify some of the issues that get in the way of us doing it, but also some of the things that help us do it, that then we can perhaps go some way towards creating environments where we are helped more often than we're hindered in applying the principles properly. So maybe, you know, something to think about as we proceed. Okay. As we've seen, the first key principle is that people are presumed to have capacity until we've demonstrated otherwise. So the question becomes, well, whose job is it to make that judgment? Who should assess mental capacity? The answer, as many of you might know, is the decision maker. But that just raises the question, well, okay, who, in any given situation, who is the decision maker? What the Code of Practice says is that the decision maker will usually be the person who is directly concerned with the individual at the time the decision needs to be made. So if it's around dental treatment, it's the dentist. If it's around major surgery, it's the surgeon. If it's around whether someone has cereal or toast for breakfast, it is the support worker who is getting them breakfast. So the decision maker does not need a qualification. They do not need to be a learned expert in anything. It is the person dealing with the decision at the time. And I think sometimes a lot of people don't feel confident enough to be the decision maker. But if you are the person directly concerned with the individual at the time the decision needs to be made, in the words of the code, then you are the decision maker. You can, and I would say you should, for major decisions, get in another, you might need to get in an expert opinion. It might be a psychiatrist or a social worker that you get in to advise. But it's worth noting that they are there to advise. If it is the decision that you're concerned with, then in the end, the duty lies with you to make the decision. You might very well ask, well, why would you get in an expert and then not pay attention to their point of view? And that's a valid question. And you might you'd need good grounds, I think, for ignoring the expert opinion, but in the end the decision is yours, not the experts. Okay. So that is very briefly who should do it. Next question, how you should do it. It's worth noting, first of all, that assessments of capacity are judged on the balance of probability. You do not need to be certain beyond reasonable doubt that someone either has or lacks capacity. Okay, but there is a two-stage test, the diagnostic test and the functional test. And I'm going to take the functional test first. Okay, the functional test is whether the person is unable to make this decision, the decision that you're concerned with at the particular time, at the time it needs to be made. Okay, so as we'll see, if it can be made later, then do it later. But at the time the decision needs to be made, is the person unable to make the decision or not? That's the functional test. And whether they are or not, you decide by going through these 4 steps. The first step that the person needs to be able to do to be judged to have the capacity to make the decision is to understand the information. So let's say you have an elderly resident of a care home and he or she wants to spend quite a lot of money on a family holiday that would include them, but also their children and grandchildren. Okay, take that as an example. Do they understand what is being proposed, this big holiday? Do they understand how much money they are being asked to contribute to it? You know, do they understand what else they could buy with that money? You know, but basically people need to understand the nature, the purpose and the consequences of the decision that they're making. So can the person think, well, okay, I understand that I'm being asked to go on holiday, the purpose of which is that we spend some family time together, but the consequence of which is I spend £2,000, and that's £2,000 I don't have to spend on something else. You may come up with better examples from your own practice, but people need to be able to understand the information that you're giving them. They then need to be able to retain the information long enough to use or weigh up that information in order to make their decision. And retaining the information doesn't need to be very long. Even for quite major decisions, it might only be for 5 minutes or so, but as long as people can retain it long enough to use or weigh up that information, then they have kind of cleared that hurdle, if you like. So the third hurdle, as we said, is can they use it or weigh it up? Now, an example that the Code of Practice uses where that might not apply is, for example, someone with anorexia nervosa who cognitively might be very able and well able, certainly, to understand the information that people tell them about, you know, their diet. But because of their anorexia, is unable to then go on and use that information because of the impairment of their mind, the anorexia. They're unable to use that information to make a decision. Okay, so that might be an example where someone can understand but can't use the information. Okay, and the fourth and final hurdle that people need to clear, if you like, is that they need to then be able to communicate their decision. And very few people, I think, should be failing to clear just that hurdle. If people can understand, retain and use the information, then they probably have some means, even if it's just the blink of an eye or the squeeze of a hand or some technologically supported method of communicating their decision. Okay? So that is the functional test. But it only kicks in if, as we've talked about, there is an impairment or disturbance in the mind or brain. And that's the diagnostic test. People have to have something cognitively wrong with them, if you like, at the time that the decision needs to be made. So that might be drunkenness, it might be dementia. It also, though, it's important to be clear that the inability to make the decision, that the failure, if you like, of the functional stage is caused by the impairment or disturbance in the mind or brain. Okay, just if someone has dementia and they're you know, faffing around trying to decide what to wear that morning, it might be that they're just indecisive about, you know, whether it's a day for the red jacket or the blue jacket. Any one of us, I know I certainly am guilty of this, can faff around in front of their wardrobe trying to decide what to wear. And that can apply just as much to people with an impairment or disturbance of the mind. So you do need to know that the inability to make the decision is caused by that impairment before you conclude that someone lacks the capacity to make that decision. I hope that's clear. It's a complex slide in a way. In many ways, it's the key slide, of the presentation, because getting the assessment of someone's capacity right is absolutely central to the kind of the proper implementation of the mental capacity. Some cardinal rules I want you to remember. You do need to have what the Act calls reasonable belief that someone might lack capacity to even begin the assessment. So don't fall into the trap of assessing everyone in a care home around whether they have the capacity to consent to their care plans, for example, because unless you've got reasonable belief to think that someone can't, then you have no business assessing their capacity in the first place. And a diagnosis in itself isn't enough. You cannot say, well, she has dementia, therefore we're going to assess her capacity. You need some grounds based on that person's individual presentation and that person's individual cognitive abilities to think that someone lacks capacity, have reasonable belief that someone lacks capacity before you assess them for it. Okay? An assessment of capacity is decision specific. Saying he lacks capacity doesn't mean anything. We might use it as shorthand and that's fine, but actually in terms of the Mental Capacity Act, what you need to be saying is that he lacks capacity to make this particular decision at this particular time. And so to do that, always be clear in your own mind what is the actual decision, and then discuss that actual decision with the person in whatever way works for them. Okay? And as I've mentioned, and as we'll look at in a bit more detail now, it is a cardinal rule that you cannot decide someone lacks capacity until you have taken all reasonable steps to support them to make a capacitated decision. Now, I think part of the problem is that sometimes we rush to assess capacity, and I think it's useful to reframe our thinking on this. And actually, if your manager says, can you assess that person's capacity, reframe it into this question on the screen. How can I support this person to make the decision themselves? What can I do to help them make a capacitated decision rather than rush to test whether or not they've got the capacity? So things that you might use to help you with that are, your communication skills, the techniques you use, any tools. It could be pictures, it could be video, it could be a life story book. You will have these things in your workplace, I'm sure. It's also about giving people the right information and not expecting people to make an entirely abstract decision, but giving people the pertinent, relevant information that they need in order to be able to make a decision. You might want to think about the location. Is it a quiet, private space where people can think through? And you might think about timing, giving people enough time to make the decision. Don't rush the decision if it doesn't need to be rushed. That's the last part on the slide there. Can it wait? It might not be able to wait, but more often than I think we allow, decisions can wait, and they don't always. I think sometimes we ask people to make decisions that fit into our organisational convenience rather than fit what is best for the person. Okay, so have we got the timing right? Is it a time of day when the person is cognitively at their brightest? It's something else worth considering. And who else can help us? Other professionals or often family. Sometimes family will know people's communication styles in such minute detail, that they will know that, say, look, if mum is looking at her shoes when you're asking her a question, that means she doesn't like the thing that you're talking about, and there can be tiny details that only family would ever know. So our job as professionals is to consult with them and kind of ask for their help, I guess. Now, this brings us to the tricky area, I suppose, of unwise decisions and what is an unwise decision rather than an incapacitated one. I'm just going to bring up some images here that I think remind us of how many unwise decisions we all make. It might be that we drink too much. It might be that we smoke too much. It might be that we reward ourselves at the end of a taxing week at work by spending perhaps a little more of our weekly income on clothes, then would be entirely sensible. One I'm susceptible to is extra pudding, not even pudding, but extra pudding. Or you might spend a little more than is wise on the lottery. You might have avoided the dentist for the last 10 years, or some people might think the unwise decision is actually to go to the dentist. Whatever it is, we are all conscious of the fact that we all make unwise decisions, and we all, I would presume, would be very cross with anyone who tried to stop us. People might advise us against it, that's fine, but actually trying to stop us would, I think, really get our goat. It would certainly get mine, and it that level of intrusion, if it's unwelcome to us, is likely to be equally unwelcome to people with care and support needs. Okay, I'm going to read you this quote from quite a famous kind of MCA bit of case law about a woman with a learning disability making decisions about spending time with a man who perhaps it might have been viewed unwise of her to spend time with. What the judge said is this, that there is a space between an unwise decision and one which an individual does not have the mental capacity to take. And it is important to respect that space and to ensure that it is preserved, for it is within that space that an individual's autonomy operates, which is, I think, kind of judge language for saying that sometimes we do just need to butt out of people's lives a bit and let them make unwise decisions. And again, I want you to think about this, because I think there's a lot of evidence that we don't allow unwise decisions, that our organisations have a tendency to try and clamp down on them. Again, something I want you to take away and think about is, are you allowed to respect people's space? Respect people's space to make unwise decisions where you work? Is that something that your manager, that your organisation, that your policies allow you to do? And if not, what could you do to challenge that? Because I do think it is really important, right, that we have to respect for people, for them to do things that aren't necessarily in their best interest. Because if someone is capacitated to make an unwise decision, it is vital that we respect that right. Okay. It is worth saying, though, and this is where it gets tricky, is that someone who makes a whole string of unwise decisions might indicate that they do lack capacity. If someone is taking flagrant risks with their well-being day after day, that might be a trigger that they don't understand the risks and they're not capacitated to make the decision. The challenge is for you is to make the judgment about whether it is an unwise decision or an incapacitated one. And for that, you need to spend time with the people, get to know them, and make the best judgment that you can. The important thing is not to rush to an assumption of incapacity just because a decision is unwise. Okay? But if you have suitably assessed someone's capacity, if you thought, actually, there are triggers here that make me think that someone lacks capacity, and you've done everything you can to support them to make a capacitated decision, and you've not been distracted by an unwise decision, but you've properly conducted a capacity assessment, you might then conclude that someone lacks the capacity to make a decision in their best interest, to make that decision at that time. And you are therefore duty bound to make decisions in that person's best interest, as the Act here says. Okay. Worth reiterating, we don't start with the best interests. Only when someone lacks capacity do we do the best interest process. And helpfully or not, what is in someone's best interest isn't defined anywhere. All there is a checklist, which we'll look at in a moment. And of course, it's not defined because what is in someone's best interest is absolutely and fundamentally individual to the person themselves. So we can't write down what sort of things constitute someone's best interest, because it will vary from person to person. And what you think would be in your best interest might be wholly and utterly irrelevant to what is in the person's best interest. So it's not about thinking, what would I want if I were in their shoes? It's about thinking, what would this person do if they still have the capacity to make the decision? Okay. Whilst making the best interest decision, it is vital that we should also aim to make any decision as least restrictive as possible and meet the requirements of Principle 5. Okay. So we're going to look at the checklist now. The first point is that we need to consider all relevant circumstances. So if it's around a medical treatment, for example, it's about thinking not just about the medical benefit, but, you know, would there be emotional or psychological disadvantages to having a particular course of treatment? So it's looking at the person in the round. You know, if you're thinking should this resident of my care home go to the music session? I know they like the music session, so we should, you know, be in their best interest to go. It might also be about thinking, well, but hang on, it is also their grandchild's birthday, and they're paying a visit later today, and actually, you know, we know how keen she is on visits from her grandchildren, and maybe we should help her preserve her energy for the visit and skip the music session this week. It's looking at everything that's going on, all the relevant circumstances, in order to make the decision. It is also, and this is crucial, this bit, about taking into account anything that you can reasonably ascertain about the person's beliefs, their values, their wishes. Okay, and it is proportionate. You don't need to phone their daughter in Canada to find out whether someone would like cereal or toast for breakfast. But if it were a major decision, you might, I would suggest you would want to phone the daughter in Canada and say, look, can you tell me what sort of things, if your mum's, you know, retained capacity, what sort of things would be important to her about this decision? Okay, so it's and crucial to that is listening to the person themselves. Even though you've judged they lack capacity, you still want to consult them as much as possible and include them as much as possible in the discussion, as well as we see here, consulting other people who might have useful information as widely as you can, again, you know, proportionate to the size of the decision to be made. And as we've touched on, but bears repeating, consider less restrictive options. The Principle 5 is absolutely vital. The kind of golden thread of the Mental Capacity Act is that we need to interfere in people's lives as little as possible. So if the same result can be achieved in a less restrictive way, go for that. Other things the checklist asks us to consider, and the checklist, by the way, is set out in the Code of Practice. Other things include, will the person have capacity sometime in the future? And if so, when? So if this decision can wait, and if it's a decision around what to have for breakfast, you know, and you know, that they might be brighter in the afternoon, then clearly the decision can't wait. But if the decision can wait until someone has capacity, then wait. As we've said, encourage the person and permit them to participate as much as they possibly can, and take into account what they're saying, even though you have decided that they lack the capacity to, you know, fully make the decision. And don't base the best interest decision. This is vital. Don't base the best interest decision solely on the things listed there. Someone's age, for example. Try and avoid ever catching yourself saying, well, you know, she's all old people love a trip to the seaside, so, you know, let's take her along. She might be a very gregarious person who does love a trip out, might be a very private person who does not like a big group outing somewhere, for example. Okay, so that's the best interest decision checklist, as I say, set out in the Code of Practice, which worth having a look at. And what is recommended is that you take a balance sheet approach to making any best interest decision, which is arguably just a fancy way of saying you weigh up the pros and cons. So, but weigh up all the pros and cons. So, as I say, not just someone's medical well-being, but, you know, think about people's emotional well-being, people's social well-being, and set all those out on a balance sheet where basically you take any option. So, you know, let's say the option is, does someone stay in their own home? Does someone move into supported living, to sort of sheltered housing, or does someone move into a care home? And for each option, list the pros and cons and the likelihood of each, you know, and if each proposed option has risks attached to it, then think about what can be done to reduce those risks. And then, even if the conclusion is blindingly obvious, write down what you've concluded and why, because it is really important to show kind of very clear workings out. You know, remember what your maths teacher used to tell you, show your workings, and that way it will help you be clear about the decision that needs to be made and why the best interest of your decision, the best interest decision you're making is one that is actually in the person's best interest. Now, again, to remind us of just how individualized and personalized this can be, again, I just want you to take a couple of minutes to think about the things that you would most want professionals to take into account about you if you lack capacity. So, you know, if a social worker and a nurse and some care home people and your family were sitting around in a room making best interest decisions on your behalf, what would you really hope they paid attention to? So for me, for example, I would hate to you know, live an independent life in my own home as an old man, you know, sitting in splendid isolation. I much prefer being surrounded by other people, and I would much rather people knew that about me and thought actually a care home is going to be a better choice for this old man than staying in his own home by himself, for example. And I'd also want them to remember how important it was that I have Marmite every morning for breakfast. So it can be big things, little things. We all have them. We all know what things are important to us. The important thing to remember is that the people that you're working with, even where they lack capacity, you know, that they have those things about them as well, that they will have and may have again in the future a very clear capacitated view about what matters, and you need to find out what that view is as best you can and provide care and support bearing those points of view in mind. Some things you're not allowed to make decisions on people's behalf about. One list is anything where a patient is subject to the Mental Health Act 1983, a very specific niche area. But there are also decisions that are so personal that the Act specifies that no one else can make decisions about these things on people's behalf, and you can see them here. Sex, marriage, divorce, adoption, and voting. Basically, areas where if a decision does need to be made around an incapacitated individual, then you need to apply to the Court of Protection. Okay, Section 5 of the Mental Capacity Act is the one that gives you the safe harbour of protection if you have done certain things properly and when dealing with people. So if you have to act in connection with someone's care or treatment, and I'm presuming if you're still listening at this point, then you do, then as long as you can explain why you think the person lacks capacity and explain why what you're doing is in their best interests, then you are acting lawfully. So vital to keep a record of this, obviously, because if you've not recorded it, then you can't explain it to a court or to anyone else. But if you can show that you've got good grounds for thinking someone lacks capacity and you've got good grounds for an argument that what you're doing is in their best interests, then you are protected by the Mental Capacity Act when working with people. Now, you're not protected if what you are doing is negligent, obviously, and you're also not protected if you do something that would be illegal. So if you think it's in someone's best interest to take cannabis for pain relief, you are not protected, for example. It's also worth noting that the Mental Capacity Act, Section 44 of the Act, sets up sets up a specific offence of the willful ill treatment or neglect of people who lack capacity, and people have been prosecuted for that. So that's an area worth knowing about. Okay. So, for example, when we talk about protection, you're protected if you use restraint in certain circumstances, and restraint could be anything, you know, could be simply putting up bed rails on the side of someone's bed, but you are only protected if you have reasonable belief that the restraint is necessary to prevent harm to the person, and that the restraint is proportionate to the likelihood of the harm and the seriousness of the harm. So obviously you cannot use the sledgehammer to crack a nut here, but if what you're doing, you know, if someone is genuinely quite likely to roll out of bed and they would break bones if they did, then the act of putting up bed rails would, I would suggest, very probably be a proportionate response to that and would prevent harm, and you would therefore be protected under Section 5 of the Mental Capacity Act. Again, another important element though is only if there is no less restrictive option to meet the need. Okay, and you know, on the bed rails example, you know, it would be valid, I think, to suggest that you could not have a member of staff in everyone's room preventing them falling out of bed, not least because that would be even more intrusive, arguably, into someone's life than putting up bed rails. Okay. Now, as I said, we're not going to talk about deprivation of liberty, but if the effect of the restriction amounts to deprivation of liberty, then you get into deprivation of liberty authorisations, which is a separate topic. Okay. A few specific areas of the Act that I want to come on to now, and one is advocacy under the Act. And the Act, as you'll probably know, created the role of the independent mental capacity advocate, which has to be used in certain circumstances. And those circumstances are where there is a decision to be made about serious medical treatment. So whether to have aspirin or not doesn't count, whether to have an amputation or not does count. So where there is a decision about serious medical treatment or a decision about where to live, and the person lacks the capacity to make that decision, obviously, because if they have capacity, then we don't need to worry about the Medical Capacity Act. So where there's a big decision and the person lacks the capacity to make it, and there is no one able and willing to be part of that process, to support them with that process, so no family, no friends, then you must have an IMCA, okay? And it is, for a local authority, the local authority will have a contract with an IMCA provider, so you can go to the local authority for who that might be. An IMCA must be brought in. An IMCA, you can also use an IMCA if there's a safeguarding situation, and again, the person lacks capacity to make decisions about safeguarding, and there's no one suitable to help. And it is worth saying that people need to be suitable. Having a family member who is available and willing to help might not be suitable if you think, for example, that family member doesn't have the person's best interests at heart for any reason. Okay, so must be used for serious medical treatment, and change of accommodation can be used for safeguarding. And IMCAs have quite, you know, significant powers. They can see a person's notes, and anyone making a best interest decision has to take into account the IMCA's report. They don't have to go along with it word for word, but they have to demonstrate that they've taken it into account. Okay. So an IMCA is one way that the Mental Capacity Act protects people, and protects people's kind of, you know, make sure that their views are represented in any decisions that are made. Another one, and a very important one, and this is available for any of us, you know, anyone in the population to use, is an advance decision to refuse treatment. Okay, so this is something that the MCA puts on a statutory footing, that if when you, at a point when you have capacity, when a person has capacity and they are over 18, anyone can say that they don't want certain medical treatments in the future. So if you are, for example, a vegan, you can say, I do not want any pain relief that has been tested on animals. Or you can say that if I, you know, have cancer, I do not want certain types of chemotherapy, whatever it might be. So any one of us can set out and advance decisions to refuse treatment. The more they are on official documentation signed by a lawyer or a GP, for example, the more likely they are for medical professionals to pay attention to them. But you might very well be supporting people who have an advanced decision to refuse treatment. And so really important role for you in that case would be to make sure that if a medical situation arises, that the medics treating that person know that the ADRT, the advanced decision to refuse treatment, exists. Okay, because if people don't know they exist, then obviously they can't be respected. If your advanced decision is to refuse life-sustaining treatment, then the bar is set slightly higher as to what it needs to say. It has to be in writing, signed and witnessed, and it has to include a statement that the person understands that refusing this treatment might put their life at risk. Okay, so if you're talking to families, talking to people about an advanced decision for someone, you know, that is worth bearing in mind. Some things the advanced decisions can't do, and they can't be used to refuse basic care. So they can't be used to turn down food and drink, for example. They're about refusing medical treatment. and they cannot be overruled by doctors if they're valid to the situation and if they're applicable. And one issue is that I think doctors sometimes do look for grounds to ignore them, but you know, either if it's you that this applies to, or someone you're supporting that this applies to, you need to have the confidence to say, actually, look, that this is a valid legal document. There are also things called advanced statements of wishes, which are not legally trump cards, but you would need good grounds to ignore them. So, you know, if someone sets out, actually, you know, when I become frail and old, I want to go into a care home, then that's something that, you know, people making best interest decisions on that person's behalf would need very good grounds to ignore. So yeah, those are also useful kind of advanced planning tools as well as the advanced decisions. Another very important thing that people can do, again, whilst they have capacity, is to grant other people lasting powers of attorney. Okay, so to be clear, this can only be set up by someone who still has capacity, and it only kicks in when that person then goes on to lack capacity. Okay, so there are two types, and they both need to be on the particular form. There are property and financial affairs lasting power of attorneys, and there are health and welfare lasting power of attorneys. And it is up to the individual which, you know, people can set up one or both, and they can set them up so that there are more than one attorney for each or just one. So there's quite a lot of flexibility, and quite a lot of flexibility about exactly which decisions the person is giving other people the power to make. Anyone who is an attorney, anyone who is given those powers, has to act in the person's best interests and has to have regard to the MCA Code of Practice. And yeah, a lasting power of attorney, if they've been given those powers, can have huge responsibilities, up to and including refusing life-sustaining treatment on someone else's behalf. But your role as professionals supporting people, it's crucial to know exactly which lasting power of attorney someone has, because if someone comes in and says, I can make a health and welfare decision on behalf of someone, and actually they only have a property lasting power of attorney, then they can't make that decision. And it's important to remember that these only do kick in when the person lacks capacity. So if someone comes in waving a form and says, I can make a decision on behalf of my mother because I have lasting power of attorney, and actually the mother is able to make the decision, then you need to be confident in saying to that person, actually, no, you can't make that decision. Okay? Now, if a person already lacks capacity and but they need someone to make ongoing decisions on their behalf, then you need to go to the Court of Protection, and the Court of Protection can appoint a deputy, a Court of Protection deputy, to make those decisions. And they have similar powers to lasting powers of attorney. The key difference is that those get set up for someone who already lacks capacity, because of course when you lack capacity, you wouldn't be able to set up a lasting power of attorney for someone. Okay. I've mentioned the Court of Protection a couple of times. It is something that might feel a bit distant and remote from day-to-day practice, and it is there for last resort. They're not going to thank you if you phone them up for a chat at the drop of a hat, but it is there as a very useful body to make last resort decisions when every other kind of attempt to work something out has been tried. Make decisions on a whole range of things about whether a person has capacity or not, about where someone should live, whether they should have a serious medical treatment, you know, a whole range of financial decisions. It is the Court of Protection that can say that actually someone is or isn't a suitable lasting power of attorney, and it's the Court of Protection that can say actually this advanced decision is or isn't valid, and you can ignore it or you can't. Okay. Court of Protection is also the body that authorises deprivations of liberty that are occurring anywhere other than a care home or hospital. Okay, and they've been very busy in that regard since the Supreme Court judgment of March 2014. But sorry, that's me straying into talking about deprivation of liberties. Okay, but outside of care home or hospital, if there is a deprivation of liberty, then it's the court that you need need to go to for it. There are, it's worth noting, you might not often come across this, but it's worth remembering in case you do, certain medical treatments that have to go to the court. So if someone who lacks capacity is having a sterilisation for anything other than medical reasons, or if there is some debate about whether they should donate organs, or if you're going to stop giving artificial nutrition or hydration, and a couple of others, then those decisions can only be made by the Court of Protection, because the court is there to protect people who lack capacity, but also to make sure that certain very serious decisions are only made after an awful lot of thought and time has gone into them, and don't have to be rushed by folks like you on the front line, rushing around from day to day. Okay. And I think with that, we've come to the end of our time. Other than to say, Sky had produced an awful lot of resources about the Mental Capacity Act. So we have online guidance, we've got films in our social care TV library, we've got an e-learning suite. And we also have the MCA directory, which has a whole host of really good quality resources, films, training sessions, reading materials about the MCA from all sorts of care homes, local authorities, pressure groups, a whole raft of people and organisations that you can just pick your way through and find something that's most useful for you. Okay, but we also offer kind of classroom training where we can come to your organisation and do a tailored course precisely around what it is that is of most interest to you. But the top thing there I'd like to draw your attention to, which is an open access training day, so available to anyone who has £125 to spend on the 18th of March here at our offices in central London, which will be a whole day course looking at kind of the MCA in general, including an overview of DOLS, which I hope might be of interest to some of you. Okay. And with that, I'd like to thank you. If you're still with me at the end, you've been ever so patient and dedicated, and I appreciate that. I hope that's been of use. I hope it's given you some flavour of just what a kind of visionary and potentially radical piece of legislation the MCA is, because it tells us that all of us, with whatever disability, with whatever frailty, with whatever care and support needs, have that right to make our own decisions and to have our personality and our wishes and values and beliefs respected if we can't make our own decisions. And as I say, if we get that right, then we are, I think, a very long way towards delivering really good quality social care and healthcare for people. So thank you very much, and I'm going to switch off now.